So be sure to follow us there. Pretty straightforward agenda for today. Welcome and introductions. We'll have the discussion in the QA. So with that, I'd like to introduce Danica Davis, the CEO and Managing Director of Merit HR, and she's going to help us introduce today's panelists.
Thank you so much, Jess. And the reason we have all that great social media is because of Jess. I see a lot of people that know me here on the call. You know, I'm not doing Twitter every day. So thank you for putting us into the new and brave new world, Jess. I am Danica Davis. I'm a recovering HR practitioner and a lifelong HR evangelist. At Merit HR, we focus on one thing: placing great HR people. We work in any industry, any size organization, but only in HR. And we've been doing that for 32 years now, I'm proud to say. Today's HR to the Next Power delves into the regulatory side of human resources. Compliance is an ever-changing and never-ending responsibility for HR. And like Maslow's hierarchy, we just can't move to things like culture and engagement and employee development without a firm foundation in compliance. Everyone knows we can't go forward if we're moving backwards because we're not paying attention to regulation. It is the base, but it is by no means basic, which any of us who have tried to do things like figure out how to coordinate leaves of absence in the state of California can attest to. We are very pleased to have representatives of the California Labor Commissioner's Office with us to share their insights and answer your questions. I'm going to give a brief introduction to two folks who have very long pedigrees, and we'll be sharing that information with you if you'd like to know more. Vaughn Boyenger is a Senior Deputy Labor Commissioner for the state of California, it's Labor Commissioner's Office, and has over 30 years of experience in the area of administrative hearings and claims management. In addition, Vaughn is the liaison for the DLSE EDD seminars and webinars statewide, and also leads the Labor Commissioner's BEP, Business Engagement Program Outreach Team. Prior to joining Labor Commissioner, Vaughn had many years in HR and consulting. We're also pleased to welcome Bart Jacka. He's a senior staff attorney for the California Labor Commissioner's Office, representing wage claimants, assisting in the civil prosecution of employers, and presiding over administrative hearings. I've said enough. Let's turn it over to our experts, Vaughn and Bart.
Well, good morning. And then on our next slide here, I'd like to introduce our State Labor Commissioner, Lilia Garcia Brower, and she certainly on her behalf, we welcome you today, and we thank you for attending this morning's presentation. We commend you all for taking interest in our California laws, and that please know that our presentation is designed to actually help employers understand and better understand our laws, and in the effort to probably and hopefully reduce labor law violations. Lilia Garcia Brower, by the way, was appointed by Governor Newsom as the California State Labor Commissioner on July 29th, 2019. As a labor commissioner, she oversees the primary law enforcement agency for the workforce protections. And the Labor Commission has 19 offices throughout the state. And throughout California employs 700 plus now hardworking public servants who investigate, adjudicate, a wide range of workplace violations, from unpaid violations to retaliation. And prior to her appointment, Lilia was the executive director of the Maintenance Cooperation Trust Fund for 19 years, and worked with a powerful team of committed individuals. And she directed the MCTF as it grew to be one of the state's most effective joint labor management organizations. And I want to say, she has been a breath of really good fresh air to state service for us. So with that said, we will start with our disclaimer. And as all things, there are disclaimers, and the Labor Commissioner has theirs. The information here today is provided for general information only. None of the information provided here should be interpreted as providing legal advice or a separate attorney-client relationship. Applicability of the information discussed may differ from an individual situations, and that is to say that even something as simple as an if, and, may, or could completely change the context of what it is you think is similar to your situation. So you should not act on the information presented here today without first consulting an attorney about your particular situation. And Labor Commissioner's mission statement is that the mission of the Labor Commissioner's office is to ensure a just day's pay in every workplace in the state and to promote economic justice throughout the robust enforcement of our labor laws. And by combating wage theft, and I'll explain what that is in a moment, and protecting workers from retaliation and educating the public, like we're trying to do here today, we put earned wages into workers' pockets and help level the playing field for law-abiding employers. This office is also known as the Division of Labor Standards Enforcement. But before we move on, wage theft could be something, well, there's people doing time for wage theft here in California, employers, because it could be an unlawful deduction, could be the failure to pay wages or pass on tax, tax monies, employer tax monies and the like. And what we also mean is by having a level playing field. And, here's an email address. It's makeitfair@dir.ca.gov. That's makeitfair@dir.ca.gov. What this is for is, let's say if you're an employer that's abiding by all the rules, you've got workers' compensation, you've got, you're paying your people at least minimum wage, you're paying them on time, and you're following our labor laws. Yet there's an unscrupulous employer out there who's not doing those things. And as a result, they're continually underbidding your services and taking business that they shouldn't have. We want to know about it. And that's why the Make It Fair email address is a useful tool. Here you see our Department of Industrial Relations website, and it's a very talk about useful tools. This one is one of the better ones I've seen. If you see on the at the top right, you'll see the query box or the magnifying glass. You can put in simple phrases like alternative work weeks or overtime of California, or any number of just simple phrases or wage orders for your type of business. And so you can generally get most of the information you're looking for right there, right then, very simply. If you look over to the far left of that same black ribbon, you'll see a section that says labor law. And if you were to click on that, you'd see where our offices are located, what city that you are operating your business in. That'll tell you which one of our offices has jurisdiction over your questions. Please know that we only have, these 17, 18 offices, and we only have about that many people answering the phones at a time. And that means when you get 70 calls an hour into our offices, that we can't always get back to you as soon as we would like. And so we're authorized to take up to 48 hours to respond. So if you'd rather not wait that 48 hours, if you don't get through, try the query box first. Okay, so we'll move right into overtime requirements. Part of our presentation today is because there seems to be a lot of confusion about what a non-exempt employee is. For example, is a non-exempt employee could be an hourly or a salary, but not salary exempt employee. There's three different things we're talking about here. And I know question marks and light bulbs are coming on right now, because you're going, wait, what? There is a salary exempt employee, there is an hourly employee, and a salary employee, not to be confused with the other. The hourly employee, but if an employee is on salary but not salary exempt, they still get overtime, for example, where a salary exempt employee would not. So those are the kinds of things that are good to know. Overtime requirements here in the state is you get 1 1/2 times the employee's regular rate of pay for anything over 8 hours in a day, or anything over 40 hours in a work week. You get double time for anything over 12 hours in a work day, and over anything over 8 hours on the 7th consecutive day of work. And again, if you just press overtime in our website there, it'll tell you everything you need to know. There are exceptions like alternative work weeks and those sorts of things, but you can get that information on our website. And in our next slide, it's important that we define what wages are here in California. It's all all amounts for labor performed by employees of every description here in California. There's been some recent case law cases that came up a couple of years ago, Troyster v. Starbucks, and more recently, Donahue versus ADM, and whereby it was a case where somebody was asked to come in, earlier than their scheduled shift to put out the tables and chairs and those sorts of things, and wasn't compensated for it. The matter went all the way through our California Supreme Court and was determined that that was compensable time. All time worked on behalf of the employer is compensable. And then with Donahue, what happened is that there was a little bit of door left open for de minimis there with the Troyster case, and Donahue essentially closed that door. So all amounts of labor performed are compensable by the employer. That means if you're driving on behalf of the employer, you're dropping off something after work for the employer, any work done on behalf of the employer is compensable. And in our next slide, we have tips and gratuities. Definition, the labor code, and I'm not gonna bombard you with labor code sections today, but it's there if you want it. Gratuity is any tip or money left or for an employee by a patron of a business over and above the actual amount due the business for services rendered or for goods, food, drink, articles sold or served to the patron. And gratuity is the sole property of the employee. Employers generally cannot collect tips for themselves. I can think of some very small exceptions, like if you own a restaurant and you didn't have any help that day and you were working the tables, then you might have a cause to be able to collect tips. But general supervisors or owners cannot. Now we've got on-call, standby time, controlled versus controlled. Give you an example of controlled. If an employer says, hey, I know it's your day off on Saturday. I know you're going to be out in your boat and on a lake. And if you, you take the company phone with you and don't let it ring more than 5 times before answering it, that's controlled time. Uncontrolled time would be if the employer does the same thing, hands you the phone and says, hey, listen, if you want to and you can, answer the phone. If not, don't worry about it. Or you might see where an employer says, listen, you got to be within 30 minutes of work this whole time. Those kinds of things would be considered controlled versus uncontrolled. And the difference is the level of compensation. Travel time, we'll stay there. Travel time, most employers are just now learning that employees are asked to drive someplace other than their normal work site to perform duties. Let's say, for example, if you have an office in Fresno, California, and you have your employee drive over to Paso Robles for the day, and which is a 2-hour drive, have 8 hours of work, and then 2 hours to drive back, all that time is compensable. And if you don't have a time rate of pay figured out for that employee for just travel time, they're paid at their regular rate of pay for the whole trip. And then we've got training versus voluntary versus mandatory. Voluntary is just simply that. You can say, hey, listen, we're having a luncheon meeting here today. If you want to make it, great. If you can't, no worries. Mandatory is certainly another matter. I've seen cases where an employer says, oh, well, we bought lunch. Did we still have to pay them? Yeah. If you're making it that they have to be there. And if you're wondering, well, you know what, if you can say, hey, listen, I know it's voluntary, but everybody else is going but you, it's no longer mandatory. It's some sort of persuasion or dissuasion, and therefore it's compensable. Doffing and donning are changing into and out of gear these days, especially PPEs. We know that's all part of something that you wouldn't be doing unless you're doing it on behalf of the employer. So it's compensable. Day of rest and maximum hours, I'll leave you to our website for more information. But we will discuss alternative work weeks. Most people are aware that there is something called alternative work weeks, and you might know them as 410s or 312s. But what most people don't realize is that if you're on an actual approved by the OPRL, which is the Office of Policy, Research and Legislation, you can have your people on an alternative work week, but you have to pay them overtime, anything over 8 hours and anything over 40 hours in a week. So 8 hours in a day or 40 hours in a week. But if you're on an actual approved, not just applied for it, but got it in, you got the letter back from the OPRL approving your program, then you're on an approved alternative work week. But in such cases, if you're on 410s, the minute you work more than 10 hours, you're still going to get overtime. You work more than 12 hours, if you're 312s, you're still going to get overtime. But the main thing is to know that you have to have an approved plan with confirmation back from the director's office. And if not, anything over that 8 hours in a day or 40 hours in a week is going to be compensable at overtime. Pay periods. These, it's hard to make paydays these days. We understand, we get it. However, it doesn't, and this one thing that I know that was mentioned early on, our laws have not changed because of COVID. They've not been relaxed because of COVID. They are still in place. So know that regular paydays for an employee, for example, if they are salary exempt, they can be paid once a month. But it has to be a set payday, and otherwise you have to be paid no less than 2 times per month if you're salary or salary exempt, and those have to be on set paydays. But if payday falls on a Saturday or Sunday or a holiday, they can be paid legally on the next business day. Employers are required to post payday notices, so that's important so employees know when they're getting paid. And there's a penalty for failure to pay wages. And it used to be that if we sent our Bureau of Field Enforcement out to an office and we realized that you weren't paying your folks on time, then we would issue a citation. But now the employees, as of January 1st of last year, of 2020, are able to do the same. They can file a claim with our office if they're being paid late. You can see the penalties, and they add up pretty fast if employees aren't paid correctly. And here in California, we do have a minimum wage. It's currently $13 an hour if you have 25 or fewer employees for each hour worked. And it is $14 an hour if you have 26 or more employees. You can see that as of January 1st, 2023, it'll be $15 an hour. And that's gives everybody a little time to plan for it. And after that, any increases will be indexed for annual inflation, if any. Next, we have the sample list of, by no means the full list, of cities and counties that have maximum wage ordinances. Now, employers hopefully understand that there is a minimum wage, a federal minimum wage. You can offer more, but you just can't offer less. That $7.25 an hour, $7.25 an hour. So in California, you've just seen we've elected to pay more, $13 an hour and $14 an hour respectively, depending on the size of the employer. But there are other cities and counties here in the state that have elected to pay even more and make it a minimum wage. And this is just an example. Would tell you right now that you're going to want to check with your city and county to confirm whether or not they have one. I would probably document who I spoke to, date and time too, regarding whatever answer you got, or if you could get it in writing back from them, that'd be wonderful. But this stems out of a case from probably 10 years ago, where I believe it was a beverage truck driver out of Alameda County was going across the Bay Bridge, driving down to South San Francisco and out of the county, and driving back in the city and county of San Francisco says, wait a minute, we've got a minimum wage ordinance here of $12 an hour, when I think the minimum wage at the time was around 10, and you didn't pay it. So there was a big tussle over all that. And what it wound up being is that once an employee is working 2 hours or more in one of these cities or counties, they're going to make the higher minimum wage. So that's what came out of it. Typical wage issues. We've got minimum wages. Everyone must be paid minimum wage for all hours worked. And this is to be noted that it's not the aggregate amount during the day comes up to minimum wage, but it's actually for each and every hour worked. So that's the huge difference. If the minimum wage is $13 an hour, you have to be making at least $13 an hour for each and every hour that you work. Split shift differential, you'll generally see that with maybe restaurant workers or school bus drivers, where they come in and, a school bus driver would take kids to school in the morning, come back to school and take them home. People work in restaurants might do the rush hour for lunch and then come back and do the dinner. But anything over 1 hour of a break is going to result in a split shift differential. Again, you can look at our website to see exactly how that works. So it's important to know that such a thing exists, though. And reporting time pay. This is probably, again, one of the more common violations we'll see. If an employee is scheduled for 8 hours that day and you send them home after 2, they're going to get paid for 4. If they're scheduled for 5, they're going to get paid for 2.5 hours. If they're scheduled for 4 hours and they work 15 minutes, they're going to get paid for 2 hours minimum. Where we'll also see this is a time of separation. Employer, maybe it was a Monday, you're supposed to work 8 to 5. You come in and the employer hands you your check and says, sorry, you don't work here anymore. If you didn't include the reporting time pay, odds are you're probably going to have a violation on your hands. So these are the things to know. Next, we have liquidated damages, and this is where employee is paid less than minimum wage. So let's say, using an example of an employee making, say, $20 an hour, but they, payday comes, they weren't paid at all, or they were separated and they weren't paid at all, then liquidated damages would apply. And liquidated damages is a minimum wage violation where you would not only get your wages that were owed to you, plus liquidated damages, which would be the minimum wage of, say, $13 or $14 an hour as an example, in addition to the wages that were owed. Please also know that commissions based on an agreement of employer or employee must be committed to writing. You have to have it in writing, the commission program. And employer is required to give employees a signed copy and retain a copy. Commission payments, flat rate or sale of goods for service which the employee did not make or perform. Barber example is the difference. Could be commissions selling shampoo, whereas performing a haircut would be piece rate. But the idea is to know that commissions, except even at the end of employment, would be due. All wages are due, and Bart will get with that, explain that further detail here shortly. At the end of employment, but commissions are as well, or the best you can tell what those commissions are due would be, or within a reasonable amount of time that you would know, not months, for sure, days more likely. In our next slide, piece rate. We've got payment method based on tasks completed by the employee. They're making something, performing a service. Piece rate only compensates an employee for the time spent working on that task. Rest breaks need to be separately compensated or added, and as does non-productive time. But the thing to know here, like for example, if you were working in ag and you were getting $7 for every bucket of blueberries, and it took you an hour to collect that basket of blueberries. And obviously minimum wage, it would be $13 or $14 an hour, or give or take a minimum wage ordinance. So just because they got paid $7 for doing that in an hour, you would have to make up the difference to make sure that for each and every hour that employee worked, again, not a culmination of the whole day, but hour by hour, was making minimum wage. By the way, on vacations, there's no requirement that an employer here in California supply vacations. However, if you do, then there are rules that apply. There's no requirement that employers offer any vacation or PTO, but there is sick leave, paid sick leave, that is required. Use it or lose it policies are not allowed, but caps on accrual are. all accrued, but unused vacations hours are due at the final rate of pay at the time of termination. So say they just got a raise on their last paycheck, that's what the final rate of payment for vacation is going to be as well. Bonuses, based upon meeting the goals set by employer, besides a percentage of the sale, commission, or an amount for something completed. Discretionary bonuses are just that, and it's the word the term pretty much explains itself. It's based on employer's discretion to award them or not. Non-discretionary bonuses are the ones that are based on some sort of metric. And the employer can calculate it, and that the employee knows that they're going to get something based on the production. Bonuses pay are due the pay period after they're calculated. Does not need to be paid if employee does not work or if there is a date for set for calculation. But again, there should be something in writing. De minimis and rounding, we've kind of already covered that. Troyster v. Starbucks, we've discussed, and we've also discussed, Donahue versus AMN, not ADM, AMN. And so again, all hours worked, anybody's working now, they're going to be compensated for. I've seen cases where an employee would come in a half hour early before work. They weren't even asked to do that. And they would come and straighten up, make coffee for everybody, that sort of thing. And then lo and behold, the employee was terminated and put in a wage claim for that time. And the employer's affirmative defense was, hey, listen, I didn't tell them to come in. But unfortunately, the way it falls down is either the employer knew or should have known this person. It was common knowledge somebody was coming in doing that. And it's up to the employer to make sure that person is compensated. And therefore, in that particular case, the employee won. And authorized deductions. At this point, I think what we're going to do is we're going to switch over to our staff counsel, Bart Jacka, and he's going to tell you a little bit about authorized and unauthorized deductions. Bart?
Thank you. And this part has more math, so that promises to be exciting. But the first part of this, authorized deductions. Only certain items can be deducted from a person's wages. Taxes, that's the normal thing that one sees on a wage statement. About the only exception is there are certain local taxes that sometimes are assessed that can't be deducted. And that's covered in section 2224, but the general kinds of taxes, state, federal, FICA, that kind of thing, can be deducted from a person's wages. Certain healthcare contributions, premiums, things like that are authorized in writing. It's very important to be clear with each employee about what is authorized, whether you've got a general agreement or more specific ones, the amounts, make sure you cover all that and people know ahead of time what is being deducted and why. And then garnishments, court orders, child support garnishments, and the like. The one thing, please do not deduct are wages you've already paid. That's a no-no. If you've overpaid an employee in the past, you're not entitled to deduct those wages from future payments to him. If the employee won't voluntarily repay the money, contact a lawyer, but do not deduct it. Just like the employee can't take a piece of farm equipment away from you because he's been underpaid, you can't deduct money from his wages because he's been overpaid. And record keeping. There's a variety of records you have to maintain. Your payroll records, timesheets, what you've paid, how you've paid it, things like that. The information that you require to give to an employee when first hiring her, the written notification that's required under the Wage Theft Protection Act, the pay rate, the name and address of the employer, the rates, all that kind of information. Keep that information in your records. You can get the templates for this and what has to be provided to a new employee from the Labor Commissioner's website. Personnel files, anything about the employee's performance, reprimands, good, bad, things like that. Maintain this kind of material. And all this material should be maintained for at least 3 years. it's probably better to keep it around 6, but at the very minimum, keep it for 3 years. An employee has the right to review and to copy this information. And if you don't let the employee do it, or you wait too long to provide it, you will end up paying a penalty. The turnaround on this is between 21 and 30 days, depending on the kind of information the employee wants to review. Payroll records are 21 days, personnel files are 30. And there are penalties for not doing this. And it doesn't matter that you don't like the employee or think the employee has a bad reason. The employee just gets to copy and get copies of these things. Doesn't matter why. Next, the itemized wage statement, which has lots of information on this. The goal of the wage statement is not just to comply with the law, but also to make it easier for yourself. So you don't get questions that are easily answered from employees, is how their rate was calculated, what's owed, how many hours they worked, how much vacation time they got, how much sick leave they've got, all those kinds of things you want to be able to have in a statement to the employee to save yourself time and trouble. And so you're not answering questions that don't need to be answered all the time. It needs to be, ought to be clear and easy to read. So you have to have the information that's required under Labor Code Section 226, which has very specific information about the name of the employee, the name of the employer, the whether the employee is paid by the hourly, piece rate, combination. If it's a farm labor contractor, not just the name of the farm labor contractor herself, but also the name of the legal entity that got the farm labor contractor, the underlying farm or agricultural company. Put on this total hours of compensable rest and recovery periods, the rate of compensation and the wages paid for those periods. Put in the amount paid for non-productive time for piece rate workers. Remember, they're compensated not just for the pieces they produce, but also for time where they're working, but not producing those things. They're cleaning up a shop, preparing for the next job, all those kinds of things. That needs to be separately listed in the wage statement. And there are penalties for failure to do this. $250 per employee per violation, and that's just on the initial one, and $1,000 per employee per violation afterward. And here's an example of an hourly wage statement. Most people are paid this way, but not everybody is. You've got the name of the company and the address, social security number, at least the last 4 digits, the pay rate, regular, overtime, pay period, which is each day covered for which the person is being paid. It's easy, and you see this, it's easy to read. The number of hours of regular time, total amount paid, overtime, total amount paid, deductions listed so the person can read them and understand them, gross earnings, deducted net earnings. And as you can put on a wage statement, which I think is the easier way to do it, how many hours available of sick leave. Pay stub for piece rate. Roughly the same, but here, remember, you're also making sure that you pay the person for at least the minimum wage for all the hours worked. So that's why you have a regular earnings with the number of hours worked, so you know that the person is at least required to get the minimum wage for that period. So you have piece rate, the number of pieces, and the amount, so that again, so it's easy for the person to read and understand and to minimize the number of questions available to you from folks who don't know how their pay has been calculated. Reimbursements. People are reimbursed for all necessary expenses connected with their employment. So you have the mileage rate, which is now 58 cents per mile, tolls, parking, meals that are other than, it's one thing for a person to take, their lunch to work. It's quite another to be working out of town and out of necessity have to get meals. That person's reimbursed. Vehicle insurance, if the company is requiring that as a mechanism for dealing with employment, uniforms, equipment, anything the employee has to pay that's really part of the job. meal and rest periods are determined in several different sections in the labor code and also in the each of the work IWC orders. Generally, however, you get your half hour of meal period that is not compensated. You get it during the day. You get an extra one if you have a longer day, 10 hours or more. If you can't pay if your person isn't afforded a meal period, then they are paid an extra hour pay for that deprivation. The affording the person the meal period means they've got to be able to take it off and leave and have a meal on their own. If you can't do that, there are a variety of situations where you can't do that. No one can leave. What it means is you've got to pay the person an extra hour pay for that time. Rest and recovery periods, on the other hand, are compensated. And if you can't provide it, you do have to pay the person an extra hour for not getting the rest periods for that day. Piece rate compensations especially include the need for recovery periods. A lot of people who were agricultural workers working outside get more than the 10 minutes required by the labor code because they need time to recover from heat and things like that. Cover all these things. You basically have to read all these things rather detailed because they're very specific. Rest areas it's a little differently than phrased. What it really means, it's in terms of the way the wage orders covers it. You need a place for people to change their clothes, get into and out of uniforms, needs to be separate from the restroom, has a locker if they have to change into or out of uniform, but a place for them to do that. And finally, you need lactation accommodations. For women who are nursing, there needs to be a private location, not in the restroom, not in the stall, for them to perform that activity. The next couple of slides cover in more detail sort of these general rules about meal periods. If you work at least 5 hours, you get a 30-minute duty-free meal period. If you work 10 hours, you get a second one. A meal period is not compensated, but if an employee works through it, then the employee is paid for this time. The only time you have to pay the extra premium is not when the employee chooses to work through a meal period. A lot of employees do that. But if you can't afford them that time, the employee is not required to take the meal period. The employee works, he's paid for the time. But if you can't provide them with a meal period, if you can't give them that opportunity, that's the circumstance under which you pay them the 1 hour extra pay for work done that day. And it's an affirmative duty for you to provide. It isn't always clear whether you've provided the meal period to somebody who chose not to take it, or whether the employee simply wasn't afforded that opportunity. Try to be clear about that. Keep it in time records. Make sure that when an employee decides to work through a meal period, which is perfectly appropriate, that it's clear that the employee decided to do it during that time, and that it was not a matter of you not providing with the opportunity to take the meal period.
So actually, I'm going to interrupt here just for a moment. We're getting a lot of content-specific questions, and I want to make sure that we are addressing how some of the things that we're discussing might apply to a remote or a hybrid work environment. We've had a lot of specific questions about, for example, the lactation room. Like, how does that translate? If you can speak to that throughout the presentation, I think that would be helpful, because a lot of people are saying this is really helpful, but how does this apply in the new world we find ourselves in?
Well, I mean, like for the example, lactation, if a person's working from home, it would be their ability to deal with lactation in the home. So I'm a little confused by that question, because no, you wouldn't have to provide a place in a person's home. I think we're talking about the work environment where you're in a limited space. You have cubicles and offices and restrooms and things of that nature that are controlled by the employer. A person's home would not be. So
Right.
I may be misunderstanding the question there.
I might have used an interesting example.
Yeah, it is. It just seems like it would be equal, you know.
And I would say that, you know what, the meal and rest periods don't go away just because somebody's working from home. If they're scheduled
Right.
for a regular hour shift, they are to take their meal and rest period just like they normally would.
Yeah, that you're working from home doesn't, you know, it may make it easier for you to afford the employee the time, but I could certainly see a situation where an employer gets docked for not giving an employee the opportunity to take a meal or rest period, even though the employee is working from home. Because if the demands are so heavy that you can't break away for the 30 minutes or for the 2 10-minute periods, then you've got an employee who isn't being afforded that opportunity.
Right. Okay, just wanted to bring that up since we were getting a lot of questions about the, you know, the new transition of what a workforce looks like. So let's move on. Just wanted to make sure that we all, like I said, there was a lot of questions, so just wanted to bring that up.
Right. Okay, there we go. Thanks. Piece rate rest periods. Of course, this is a person who isn't sort of working and being paid by the hour, but is paid by the thing that the task or the item produced and so on. So this gives you an example of a person assigned to form piece rate work each day. Works 8:30 to 5 days a week. Takes a half-hour meal period, takes 2 rest periods taken in the middle of each work period. The standard kind of setup for a person, regardless of whether they're being paid by the hour or by piece. They earn $500 a week for what they have produced. There are 40 hours of time assigned to the work. The rest period hours is 100 minutes divided by 60. That means it is the number of minutes you were allowed to, you took 20 minutes a day times 5 is 100 minutes. Divide that by 60 to get the 1.67 hours. In other words, the person spent 1 3/4 hours per day in a rest period for which they're paid. Their piece rate hours are 40 minus that. That is, they were not working during that time. So that's deducted. So they have 38.33 hours where they actually worked on whatever task they were doing. Their hourly piece rate wage then is the total number of earnings for what they produced divided by the number of hours they spent producing them. That's $500 divided by 38.33 hours. You get an hourly rate of $13.04. Their rest period payment, which is separate from the pay they get for making things, is $13.04 times the 1 3/4 hours they paid. You add that to what they're owed for the pieces they did. That's how you get $521.78. This is not, it's only easy once you've been doing it several times. And so the best way is to get and work on a formula and apply it, and you get the idea of how to do this, because it's not that obvious. But that is the process you do to determine this. Okay. Flat sums bonus. Again, more math. Lots of fun. This was set out by a California Supreme Court case on how to pay people who get a flat sum bonus. It's often paid to incentivize certain productivity or to work on certain days. And the effect is not just they're owed the $50 or the $100 or whatever it is, but that it's factored into their regular rate of pay for purposes of calculating overtime. The reason for this is because it's to avoid employers playing a game where they pay somebody the minimum wage, which would have a relatively small overtime premium, and then they give them a big bonus and say, well, the bonus is separate, it doesn't count. No, The bonus is spread out over the hours you worked, and that's how your overtime premium is determined. So you flat sum, when determining the overtime pay, you treat it as if it were earned on a per hour basis through the relevant pay period. That's the basis on which you determine what they get on overtime, not the base rate and then just adding the flat sum to the end. The second kind of quirk here is if you're paying somebody 2 or more rates during the work week, you use a weighted average, which is not a very illustrative term, but you take your total earnings for the work week, including what you earned during the overtime hours, and divide it by the number of hours worked during the work week, including those hours. When you do that, you get a weighted average, that is, what was the person paid per hour for his regular pay and for his regular pay for each of the hours he worked from 1 to 42. It's that basis on which you determine their overtime premium pay. There's this couple of, okay, thank you. That's fine. Go ahead. Go ahead. Yeah, thank you. Time off. The point of talking about time off is this, is you cannot treat an employee adversely when they take even unpaid time off for these purposes. Jury duty, serving as a witness. There's a section in the labor code dealing with a person who's a victim of domestic violence or sexual assault who gets time off, victim of crime. They have to show up after school because their child's been suspended, visiting the child's school daycare facility, sick leave to attend a family, and voting. Although California is an at-will employment state, which means you don't need to give a reason for firing people, there are a whole list of reasons you can't fire people. In addition to the ones we normally think of, like race and sex and things like that, you cannot fire or treat someone adversely or affect their promotions or do things like that because they've done certain activities, and one of them is taking unpaid time off for these purposes. Vacation. Vacation is done, no matter how it's promised, you earn it, you accrue it as you work. So if you're promised a week per year and you're hired on a certain date and then you're fired, it accrues at a rate as discussed at the bottom. You work 40 hours per week divided by 365 days in a year. That means you accrue vacation time at this very long number of 0.109589. You multiply that by the number of days of employment, and that's the number of hours they were due. So whether they had the right to use the vacation time or not, if they accrued it and didn't use it, regardless of why they didn't use it, they are paid for that at the time they separate from employment. That's to keep employers from promising vacation, not allowing the person to use it, firing them, and then just saying, well, you never used it and you never had the right to use it and you're fired, so you don't get any of the money. You do get the money. It accrues at a very low rate per day, but it does accrue. Paid sick leave. By the way, this covers only regular paid sick leave. There are a couple of laws that have been passed in the last 2 years dealing with COVID-19 and more recently with vaccinations. This does not deal with that. This deals with regular paid sick leave. And you are entitled, beginning on 2015, you're entitled to paid sick leave. Accrual began on July 1, 2015. You have to have worked in you work in California for 30 days in a year to be entitled to sick leave. This does not mean 30 days from the beginning of employment. You begin to accrue sick leave the day you begin. But whether you're entitled to it all is a function of whether in a year you work for 30 days. So if you had somebody who worked, for example, 3 days a month, that person would be entitled to paid sick leave. There is a 90-day accrual period before you can take it. So you need to have worked at least 3 months before you can start taking it. You get 1 hour leave for every 30 hours per worked, but it's capped at 3 days or 24 hours taken per year, and they can accrue it. You can cap 6 days and 48 hours. They can cap either of those things, how much you take in a year, how much you can accrue in a year. And employers must track what you've accrued and what you've used and provide that in writing to the employer. We saw it on an earlier wage statement. Employer mandates. Especially because this is new and because it is a little complicated, you've got to be able to have the poster on this, which you can get through the Labor Commissioner's website, a place where employees can read it easily. As with other notifications you have to give an employee about your name and wage rate and things like that, provide this with this information at the time they're hired. You've got to provide them with 24 hours or 3 days of paid sick leave for each eligible employee to use it per year, whichever is more. Allow them to use it upon a reasonable request. They do not have to provide you with a doctor's note or anything like that. They say they're not feeling well, they're not feeling well. They get to use it if it's available to them. Show how many days of sick leave are available. It must be on the pay stub or on a document issued on the same day. Preferably it's on the pay stub, but if it doesn't fit or you don't want it or can't do it for some other reason, provide it to them on their payday and have it on a piece of paper. And keep it, as with other records, for 3 years. Paid sick leave. This is basically have to do with retaliation. There's a variety of things here that you cannot treat an employee adversely for. Asking questions about safety, requesting safety equipment, seeking assistance from the government, complaining about workplace safety, refusing to perform work that violates an occupational safety law. And in most areas of California at the current time, COVID-19 is included in those things that could create that kind of hazard. You may not treat an employee adversely for any of these reasons. Workplace postings. Yes, these take up a lot of space. All are available on our website. The IWC order applicable to the people working your employment, the notice of when payday is, the minimum wage law, the wage theft protection template. That's the one that requires you to provide to the employee all the information about their wage rate and who you are and things like that. The workers' compensation, whistleblower protections, and time off to vote. These must be provided in a place available to the employees. Also, it can be done electronically in places that do not have a central physical place of employment. Finally, termination. A person who's discharged must be paid at the time of termination. If you quit and give 3 days notice, then you have to be paid all wages at the time that you end, provided you gave notice. If you didn't give notice, you've got to pay the person within 72 hours. Pay them all undisputed wages. If you have a dispute with an employee, don't hold back all of the money because you're disputing some of the money. Pay them every dime, including for accrued vacation, that you believe they are owed. If there's a dispute, you can deal with it later, but you will be treated as owing a waiting time penalty if you don't pay somebody money they're owed because you've got some kind of outstanding dispute with them. Get rid of the dispute separately from paying them the money they're owed. And the late payment penalties, which are your daily wage, can accrue for up to 30 days. So you can pay a hefty penalty for not paying somebody final wages and being willful about it. And often that amount exceeds by a huge factor the amount you may owe them.
Okay, so that is the end of our content, but we have a ton of questions, and thank you all for submitting those. I know that we've gone through a lot of information and we tried to get through as much as we could in an hour. So a lot of the questions are situational. I'm going to try to, amend these to be applicable to kind of a more general audience. So bear with me here. So on the topic that we are currently on, let's just dive right in. If we have a whistleblower, for instance, in the handbook, do we still need to post that, the item?
Correct?
Jess, do you mean if you have a whistleblower policy in your employee handbook, do you need a separate posting? Is that the
Yes.
question? Okay.
Yes.
Yes.
Okay. So I'm going to start back at the top. Again, we have a ton of questions. So in the event that we do not get through all of the questions, I can pose them in an email to our panelists and we can get back to you that way. And again, the website is a good resource for a lot of this information as well. But let's see, can an employer count on the COVID-19 related supplemental paid sick leave provided pursuant to a local paid sick leave ordinance towards 2021 paid sick leave under California law? Very, very specific question.
If I'm understanding the question, I think the answer to that is they're separate requirements. The 2021 ended on December 31st. Is he asking if you provided lots of time to an employee, does it count for 2021?
Yeah, so here's an example. If an employer provides a full-time covered employee 40 hours of COVID-19 related paid sick leave, for those 40 hours, would they count towards the employer's obligation under 2021? So long as the leave provided is a reason listed? That's the question. That's
No,
the
they're two separate laws with two separate requirements.
Yeah. Okay. Right. And I'm learning about this as well right now. So please bear with me as I ask these incredibly complicated questions. And that's why we have you here.
Right. Well, and with some of the COVID stuff, we're learning too, because it's these are fairly new laws. So.
Yes, of course. Let's see here. Does the DLSE have jurisdiction to enforce all California municipal minimum wages, even if the employee is being paid properly under the state law, but not the local law?
I guess I'll take that one because that was part of my section. And there are certain places like, say, San Francisco, that they have their own like labor commissioner's office. And Bart can chime in here, but generally that's kind of been a gray area, but they are essentially responsible for their own laws. We generally are going to take jurisdiction over anything we think is relative, but certainly the ones having to do with the state minimum wages. Bart, I don't know if you have anything you wanted to add to that or not.
I believe that has been expanded a bit. That is, if you have it's a little weird. If you have a state law wage claim, then in those circumstances, if the person was entitled to a higher minimum wage under San Francisco County or Los Angeles County, we could adjudicate that as well. If that makes sense. That way you don't have two separate bodies doing the same thing. You have us looking at a claim that says you weren't paid the state minimum wage and you weren't paid the local minimum wage. And because at least there's a state minimum wage at issue, we can look at both issues.
But if they file one, they can't file two different claims.
No, they can't be duplicative. We would end up, one or the other would end up to miss. I don't think the city isn't going to adjudicate the state minimum wage. And if you have filed, well, the city isn't going to, you almost couldn't get away with it. I think if you try to adjudicate it in two different forums, I'm not sure what we would do about that. I could see somebody saying I wasn't paid the LA minimum wage. I wasn't paid the state. They filed two separate claims. If the employer points that out to us, I don't know what we would do with that particular claim. I'm sure there's an answer. I just don't know the answer off the top of my head.
We would submit it for legal referral. We would get an answer. That's why I'm saying it's kind of a gray area, because it is, in fact, in a way, we'd have to take it on a case-by-case basis.
Right. If they file a lawsuit, we won't hear it. But when it's done in the city and the state, that's a little different. I just don't know the answer off the top of my head.
Right.
So more questions about this gray area, of course. So given that many businesses were closed during the first part of the pandemic, do you all interpret an outside salesperson any differently or offer any breaks during that time period? You approach like an outside or a consultant kind of situation?
We don't.
Okay, next question.
Well, that one wasn't Greg, Yvonne. No, we don't.
How about,
Well, and you know what, let me expand on that for just a
sure,
moment.
sure.
Just because you are salary exempt or salary or any or hourly, none of that changes. For example, if somebody's working from home, it doesn't change. We're still going to go off the salary test and the duties test, not a title, but the salaries and the duties test. So bottom line is, working from home doesn't automatically make you an independent contractor, won't make you an independent contractor if you're still salary exempt or a salaried or a salary or an hourly employee.
All that COVID did was increase the number of people who were doing something they already were doing before the pandemic. Lots of people work from home, and now many more people were working from home. And so whatever you were doing, none of the laws changed. That's why I say meal and rest periods, all those stuff, those rules stayed in place just as prior to COVID. If you're working from home, it's more likely you're able to take the half-hour lunch and the rest periods, because you can just walk away from wherever you're doing your work, but you still have to be afforded the time to do that.
Pardon, Vaughn. I think on the outside sales, as I would kind of try to interpret that question, it's because with so many businesses closed, there weren't sales to be had.
Oh.
So if they were outside salespeople that didn't have an opportunity or couldn't make their numbers because COVID, blew up their world, is there any leniency on how you paid them as an outside sales? And what I'm hearing you say,
no. They aren't an outside salesperson. And if they all of a sudden were an outside salesperson and are working from home, they're now an inside salesperson.
And if they don't meet the salary test because they can't, then they're, that's probably where it's going to wind up. They're just not doing that work anymore.
That's right. And just like you said, some of the simplest questions we got early on when all this happened was, can I now pay less than minimum wage because of COVID? No. Can I make an employee take paid sick leave or vacation? No, you cannot. Those things, our laws have not relaxed in any way, shape, or form as a result of COVID.
So how is the department interpreting principal place of business in the context of travel time? Say someone's working from home some days and the office some days. Is there a hard and fast principal place of business that?
The quick answer is going to be, it depends. It really does. We need more information, we'd like to know more about what industry they're working in, what's now being considered their primary work location, for example, if it's still a fixed brick and mortar building or if it's now their home. And we would need a lot more detail before we could adequately answer that question or accurately answer the question.
Right. And again, it's the same as it was prior to COVID. COVID just increased the number of people who were doing odd things, but it didn't change the rules governing odd situations. So somebody, if you're operating your business 3 years ago out of your garage, and you're still doing it, and people are working from home, and nothing changed about it other than the number of people who were not going to a separate place to do their work, but the rules all stayed the same.
So if an employee gave permission to wait for a direct deposit after their last day worked, is that allowed in a kind of a sub question? Can an employee sign an authorization to allow their employer to withhold overpayment? Two separate questions.
Or before the fact?
So I guess an answer for both situations would be helpful. One is, after the last day worked, if they want to wait for their direct deposit, is that allowed? And during, I would say in a current employment status, can they sign their authorization to allow a withhold for overpayments?
With respect to the late payment, you're only assessed waiting time penalties if your failure to pay late is willful. So if the employee, the safest way to do it is to just cut the person a check. Forget about direct deposit, give them their check on the date of discharge or 72 hours after they gave you notice. But if they do authorize you to do it in direct deposit, say at the next payday, then you can do that, and you're not likely to be held to have done it willfully. That makes sense. In other words, you reduce the likelihood that you'll be penalized, but it's a less safe option than simply cutting them a check. And a lot of businesses will simply cut you a check. They're not going to screw around with the direct deposit stuff if it poses a little bit of a risk to them. On the other part about, no, don't withhold the money. The employee is entitled to write you a check for the overpayment, but do not, even if it's in writing, don't deduct it from the next paycheck. It will it will cause you a problem. You're not allowed to do it. There's no way to tell the employee who voluntarily did that from the one who was coerced. And so the safer practice, the one that's keep you out of trouble, is no, just write me a check for $100.
Well, and then there's another piece of this too, and that is, you know, employers inevitably are going to ask, well, can I pay for a pay card can I give them a pay card or make a deposit into their account without asking them? And the answer is it's when they have actual access to the money. So if they don't have, if you want to pay them through a pay card or you fund it that same day of separation, but the money's not available for 3 days, you could theoretically end up with 3 days of waiting time penalties. If an employee didn't ask you to mail them their check and you mailed them their check and it takes 4 days to get there, you theoretically could be responsible for 4 days of waiting time penalties.
If you do mail them the check, at least do it certified mail, return, do it in some way where you can document the date on which you mailed the check.
But again, it's still going to get down to when do they have access to the money.
So questions about city unique minimum wage or even county, now that some of our workforce are working in different places, does that affect what they're getting paid depending on if they're working in Los Angeles today and somewhere in Orange County tomorrow? Or, does that change? Does the minimum wage
talking about physical presence?
Yes. What is an office? Is it, talking about minimum wage and how that might affect people who are working in multiple locations?
It's where the work is performed.
So if they worked half a day somewhere and a half a day somewhere else that are different locations, those are different wages?
As long as the minute you're in, say I'll just use an example, say you had an employee in Bakersfield, California, send them to LA and it takes 2 hours to get there. And so once they're in LA City and County, and it's probably a bad example because they also have something having to do with unincorporated areas, which is a little confusing. But that aside, they have to be in that city or county for at least 2 hours before the higher rate of pay would take place. And so that's where you want to look. And the other thing we'll see is in hearings where employer says, well, yeah, they're supposed to be there that long. They got stuck in traffic or whatever. Well, it doesn't matter. It's the length of time that they were there. If they weren't intended to be there for 2 hours, that's unfortunate. But the minute they're there for 2 or more hours, they're going to be entitled to the higher rate of pay.
Okay. Let's see here. This may be a pretty direct question. Are exempt employees ever eligible for overtime wages?
I don't want to obfuscate the question. It could depend. I know if you look really close, and I'll leave it up to Bart to say, but if you're working so many hours that it comes down to making less than minimum wage, it would be an interesting question to have come up. Bart?
As a general rule, if you're exempt, you're exempt. And there are people who are exempt who work just insane hours and who probably may be working less than minimum wage. But I don't think it makes them not exempt. I'm pretty sure that is not a floor.
I agree.
When I was a brand new lawyer, we used to joke about the fact that we were probably at times earning less than minimum wage and nobody cared.
Okay, I'm just scrolling through the questions here. This one is, should multi-state employers based in California code the California supplemental paid sick leave and the federal sick leave under ARPA differently in payroll systems for tax purposes?
We don't do tax questions. We don't have jurisdiction over them. Bart,
Yeah,
I don't know if you have anything else you want to add to that.
Nothing, no. No idea.
We don't do taxes.
So some other just clarification questions. Some folks were interested in the mileage reimbursement, and they were reading that it might be a different rate than what we communicated.
It's 56.
It's 56.
Yeah.
Okay.
58.
Okay. So it's 56 now. Let's see here.
The 58 was last year, 56 is this year.
Aha. Okay. For job relief, trainees under Conservation Corps, which labor codes or protections apply?
That's a state agency, is it not? And so it would really depend on if there's a collective bargaining agreement and that sort of thing. We need to know a lot more information, and if they want to forward that in the form of a question more direct away, we might be able to respond, but there's no way to know for certain based on the question.
Okay. What home office?
We may take jurisdiction over certain things, but again, it would involve us doing a legal referral to our department.
So can we talk about what home office expenses might be reimbursable as business expenses? Or is that a per business? Is there a specific list of those things according to the DLSE? Well,
that's really fluid, Bart. I don't know if you want to lead off on this one, and if there's more I can add. It's a gray area right now. It's very fluid right now. I can say that.
Right. There's no list. I don't even know how you'd make a list given the variety of situations. The law says necessary expenditures shall include all reasonable costs. And that's a fun argument, but I don't know where you'd find a list, or, that's going to be a function of sort of law firms that help employers setting things up and helping them navigate their way through the process, but there's no list.
Or also maybe even just an employer and employee working out what's fair.
Yeah.
But I know that, like I said, there's a lot going on with that right now. I mean, you could work off the basic premise that it shouldn't cost an employee money to work for an employer. This is different than driving to work, that sort of thing. But once on job for the employer, it shouldn't essentially cost the employer any money, the employee any money to work for this employer. But that's not going to fully answer the question that it's being asked. We're not going to make a ruling on that today. Not even, we couldn't.
This area changes even aside from COVID. Different cases come up where you're dealing with an employee who has to pay extra for a cell phone plan because of the number of calls being made from a personal cell phone, or maybe didn't have, and this was 30 years ago, didn't have a cell phone, but was supposed to get a cell phone to do work, out on the road. And it just develops as time goes on, and there isn't, all there is just general ideas you get about what's reasonable, and it takes time, and there's no list available or real definite.
I wouldn't advise any employee to go out to buy some $1,000 piece of furniture without first talking to the employer first. That's for sure, and expect to be reimbursed for it. So it really gets down to a matter of good communication between the employer and employee to try and figure out what's fair. But again, that's out of our purview.
A lot of these rules are a function of, in terms of operating under them, are a function of trying to use common sense and minimizing your risk. You're not going to get rid of it. You're just going to reduce the level of friction, the level of problems, and the level of unhappiness that leads to claims in front of us or lawsuits in court.
That's right.
Okay, let's see. Could you quickly touch on pregnancy and maternity rights, specifically around promotions and wage increases while on a leave?
I don't think that comes under our jurisdiction either. Sounds like something more for DF&H, Department of Fair Employment and Housing.
Okay. How about, does the supplemental paid sick leave apply to employers who are subject to a collective bargaining agreement?
The one that's currently in effect does. For 2021, it specifically does.
So some folks are asking for a little bit more clarification on minimum wages. So for remote workers, do employers have to comply with local minimum wages where the employee resides?
If that's where the work is being performed.
Okay. Okay. I'm just making sure that we are getting all of these questions. Multiple people asked a variation of the same question. Good. Can you talk about it? I know we touched on the workplace postings, but are there, best practices that you can talk about, or, what some things do work or don't work better than others? We're wondering about that as well.
Art?
I'm not sure if I understand the question well enough to, what you usually see is a big spot in the place of employment that has all of these posters, and they've got to be accessible to the employees, easily accessible. That's why putting them in the employee handbook doesn't work, because the employee handbooks kind of get put under a rug. It doesn't work. It's got to be available, and or electronically available. You don't have one, but I don't know what the person's thinking about with best practices.
Probably mostly around remote work, Bart, that if you have a company intranet is putting it on there and then advising people that this is where they are, is that enough to be compliant? Should you be creating an email that has links to them all? I mean, how do employers ensure that they are compliant in the remote workplace?
Yeah, aside from,
you mentioned they can be electronic, but what have you seen work best when they're electronic is the question.
this employer is joking. I don't think I want to send a giant poster to each of my employees.
Well, and that's just it. We don't need you to make a mural out of your wall at home.
No.
But I think the electronic part is the answer. We're not going to really give you we couldn't provide, we don't have jurisdiction over the mechanism other than compliance, or at least you can show you're trying to comply. If you electrically supply that to them, maybe get them to acknowledge that they've read and understand it, and if they have any questions, that sort of thing. But electronic might be your way to go if somebody's working from home. You're not going to really expect them to hang all this stuff on the wall at home.
No. And I guess if you talk about best practices, especially, not everybody has a computer. Not everybody has the internet. So, it just prints them off and put them in the stack. And if somebody asks and says, I don't have a computer, hand them a stack of the posters. They fold up. They don't take up 55 feet. They're just little posters that fold up. And if somebody wants a copy, you can give them a copy of whatever it is. And you can get them from our offices or from all over the state. And a lot of them are printable off the internet. So that's available to you as well if you've got an employee who simply doesn't have the internet. Lots of folks don't.
I think that covers all of them. Gosh, there's a lot of questions, and I thank you very much for kind of getting in the hot seat there. I know there's very specific questions. People, obviously are having, I wouldn't say a hard time, but we're all, again, in this gray area, and so we're learning together. And it's good to know that the website is there, and maybe I'll send the link to that again, and I can put that page back up as well. But I will leave it to the three of you, Bart, Vaughn, and Danica, for any closing thoughts. And then we can wrap up here in a few minutes.
Any words of wisdom to share, Vaughn or Bart, as we close up today?
Well, we certainly hope that everybody has learned at least a couple of good tidbits today, things that they can use. Certainly, if you have questions, by all means, contact the folks at Merit HR who will let us know what the questions are. We'll endeavor to get them for you. But again, we commend you all for being here today and trying to learn more about our laws and hopefully help alleviate the opportunities for violations to occur. Bart?
I concur. These are very complicated laws. There's a lot of information, but the best we can do is hope that you came away with a couple of things you remember, and with regard to the rest, you know where to get the information that there's no way you remember it after an hour of this.
Well, very good. We've been honored to welcome you both, and we really appreciate that you reached out to us. I think that, as you shared, Vaughn, when you first called, that most folks don't know that the office has this outreach program to help educate employers and which helps employees, right? So it still stays firmly within your mission to help employers. And as you and I discussed, I think most people try to do the right thing, but sometimes the right thing is pretty darn confusing and you need a little help to
That's
get
right.
there. Those aren't the things that make the splashy news, right? Where employers are willfully trying to do things that aren't in employees' best interest. But I like to live in a world where most people try to do the right thing. So I think that's where I'll stay. And we appreciate both of you sharing your wisdom and hope that everyone who joined us today, again, as both of you said, if you learn one thing that helps you, then it was time well spent. And please reach out to Jess and I. If you have additional questions, we're happy to forward them. As Jess mentioned, we will be posting a recording of this session on our website and on our YouTube channel. Jess, somebody asked me specifically about the slides. I think it's just the whole presentation, right? There's not.
Yes, so it's exactly. It's the slides, and in the upper right-hand corner will be the person who is presenting. So the slides will be the dominant view.
Okay. All right. Thank you for that clarification. With that, we hope that you all go out and don't violate any labor laws. Have a great day, everyone.
Thank you.
Bye.
Bye.